Hello, welcome to this session. I'm very excited to be here to share with you staffing strategies for clinics, understanding when to hire employees versus contractors. It's a really hot topic at the moment. There's been some recent changes, so it's a good idea and good timing to start getting your head around this issue. Now, I'm a lawyer, and you would be disappointed if I didn't include a disclaimer. Oh, just cut off half my head. This presentation is for general guidance only. Legal advice should be taken in relation to actions on specific issues, which is always good advice. But I will be giving you quite a lot of information in a relatively short period of time. So please, if you do want to take action on it, get some advice first that is tailored to your specific circumstances. All right, who am I? My name is Sarah Bartholomeusz. I am the principal of a law firm called You Legal. We always focus on you as our client rather than us as the lawyer. That's why we called You Legal. And we've been working with allied health professionals and other health providers for the last I don't know, like 8 years maybe. We've been in business for 11 years, and we really started focusing mostly on health professionals around 8 years ago when I wrote a book called Growing a Medical Practice from Frustration to a High Performance Business, which really was kind of because I come from a family of doctors and allied health professionals, and I saw that they did sometimes have professionals in their court that weren't always on their side. And that is something that I want to know that I'm really focused on protecting health businesses so that they don't get into trouble or they're best prepared if trouble is brewing. So hopefully that's a good indicator of why I'm talking to you today. All right. So, understandably, when you're looking to bring someone new into your practice, there's a lot of focus on what will reap the most benefit and minimize the most risk, depending on how you run your business. We find psychologists, for example, are particularly interested in minimizing risk, and some other professions don't really think too much about risk. They just want to plug the hole and make sure that they're able to service their clients or patients. So you might be on a spectrum in between those. But one important element to consider when you're engaging with a new team member is whether they'll be an employee or a contractor. And you might have different categories of people within your practice. Initially, you might need some administrative support, and generally, administrative support is employment related, or you might have some other form of allied or non-allied person that you want to bring on, and they might be an employee or a contractor, depending on how you've set up to run your business. What I'm going to talk a lot about today is how you might engage with other practitioners, because that seems to be the more complex area when it comes to health. And also, it's very important for you to understand the legal obligations and implications as you grow your business. So it can be a more complex issue within the health industry because, as you might know, in some different allied professions, many practitioners wish to work as independent contractors within a practice. And for practice owners, there's a lot to consider when answering the questions. The question, should we hire practitioners as independent contractors or as employees? And you might not always feel like it's within your decision. But as the business owner, if you're getting pressure, for example, from a practitioner who wants to be an independent contractor, but you need to know that as the business owner, you are the person who takes on the risk either way. So getting it right is absolutely critical. Okay, there are a number of models of engagement in allied health. I don't want to confuse you, but there's multiple ways that you can engage allied health professionals. And hopefully you have heard of a few of these models, if not all. Allied health professionals, as I said earlier, often like to be engaged as independent contractors because it can be perceived by them as being a more flexible choice. And there's also a belief that they'll be paid more as an independent contractor. Because they're being paid for the actual clients they see potentially, rather than there being an overhead taken out for the employee aspect. So I guess I've been thinking about how to present this to you in the least complex way, because employees and contractors are the most common ways that you might wish to engage allied health professionals. In this session, we're going to take a deep dive into each of these, and we'll explore how the independent contractor and employment arrangements are differentiated and what are the different indicators of each relationship. And we can look at how to minimize the risk within your practice, because it really is something that you don't want to get wrong. And I will explain that in a little bit more detail as we move forward. You might, I'll explain the other two in here very quickly. Services agreement with independent practitioner is a step away from them being an employee. It is much more like they are operating their own business within your business operations, and just kind of doing their own thing. And that's the same with a license or room rental arrangement, where the employee is the practitioner is renting a room only, and you're most likely the head tenant, and then you sublease or license a room to the practitioner to do their thing. So there are other arrangements that exist. I just wanted to point that out. But when you're a smaller business, most likely you'll be considering between employee and contractor distinction. All right, key concerns for clinic owners. In the eyes of the law, a contracted practitioner may, in some circumstances, be deemed an employee, as if it needed to be more complex for us. There is such a thing as being an employee for all purposes, but also for superannuation purposes or for payroll tax purposes. So there's different tests, and it can become highly problematic for you as the practice owner, but it will be highly, and always is highly, fact dependent, and will be determined based on a multitude of indicators and a multitude of tests. The legal landscape that surrounds the employee and contractor relationships has been complex for many years, which leaves practice owners to grapple with potential issues around superannuation and leave obligations, and considering the risks of sham contracting. The case of Thomas and Nars against the Chief Commissioner of State Revenue in New South Wales has brought to light additional tax considerations, prompting practices to evaluate risks associated with retrospective tax, payroll tax bills and future obligations for larger clinics. It's all turnover dependent, and I'm not going to do too much of a deep dive into Thomas and Nars and all of the state revenue rulings, but it's definitely something I want you to be aware of. And if you need to do a future deep dive with us, or talk to your accountant initially about it as a first step. Typically, when a practitioner is hired as an independent contractor, they are in effect running their own business. They'll have their own ABN and all of the obligations that go along with business ownership. So taking out their own insurance, they're paying their own tax, and generally their own superannuation as well. Whereas if they're deemed an employee, the practice is responsible for paying the practitioner's superannuation, payroll tax if you're at that level, and any leave entitlements as well. The main risk for allied health clinics is not actually you as the owner or the practitioner you're bringing on board that makes a decision as to the terms of the engagement. Even if you have a contractor agreement in place that says that they're independent, it is the law that decides if someone is a contractor or an employee, which is why I said earlier that you as the practice takes on the risk. You might think that this agreement is going to protect you. Maybe a business coach or your accountant or someone in a similar allied profession has given you a template and said it's all fine. But unfortunately, I've seen cases where, for example, a contracted practitioner chooses to leave a clinic and then it transpired that they should have been classified as an employee. As a result, upon exiting the clinic, the owners were left with a hefty tax bill for unpaid payroll tax, superannuation, and entitlements to cover. For this reason alone, it's a worthwhile exercise to make sure you know what's involved in determining whether your contracted practitioners would be classified as employees and ensure everything's set up correctly from the start in accordance with the law. However, as I'm about to point out, it is important also that these contract terms reflect what is actually happening in the clinic. It's not just an agreement that suits you for other reasons. All right. These are the recent amendments that I mentioned at the beginning. So there has been recent amendments to the Fair Work Act for constitutionally covered businesses. And what that means is if you're incorporated as a company, these will apply to you. If you're still operating your practice under your own name and an ABN, it's not as concerning, but if you're wanting to grow, you'll most likely quickly be incorporating a company. So the determination is made now with these changes, which happened in August 2024. So recently, when this was recorded, the whole of the relationship as reflected in the terms of the contract, and additionally, how the contract is performed in practice. This new test differs from the previous test, which placed a focus on the terms agreed in the contract. In practical terms, this means that going forward, even if the agreement terms clearly indicate the relationship is one of principal and independent contractor, then there could still be a risk that they could be considered an employee based on how the contract is performed in practice. Therefore, if contractors challenge their engagement status, they could be successful in seeking employment-related benefits like unpaid leave, entitlements, or superannuation. Determining whether a worker is a contractor or an employee in practice and in the contract depends on a number of indicators, which I'm going to get stuck into explaining for you now. The most important part of making sure you're on the right side of the law is understanding the indicators that help determine whether a contractor or employee relationship exists. We cannot call them rules specifically, as each indicator alone will not be enough to determine whether a relationship is that of a contractor or an employee. Bear with me too, as there are quite a lot of different factors for us to turn our mind to, but we'll get started with one very important factor, which is the level of control and independence that a practitioner has. Independent contractors have control over how many hours and what hours they work. If you dictate to your contractor when and where and how they must perform their work, you may be, in fact, positioning yourself as an employer. We understand that this creates Some difficulties for clinic managers who need to ensure that there are practitioners available consistently within the practice to see clients. However, let's say, for example, you engage a practitioner to work on Monday, Tuesday, and Wednesday. It's not necessarily taking away their control and independence, particularly if we consider that these hours were likely negotiated with the practitioner during the hiring and contracting stage. If, however, you have engaged the practitioner on these terms and then make additional demands or requirements, such as they must arrive 15 minutes before their shift for a team meeting, or they must be available on call after hours, this is moving into more of an employer-employee relationship. Other examples of this include expectations that they schedule a certain number of patients or clients per day, or they must not take more than 2 15-minute breaks in between scheduled appointments. You can start to see how this quickly starts to include more control than a true independent contractor relationship. The next indicator is exclusivity, which means a true contracting practitioner will either work for others as well as your clinic or be permitted to do so in both practice and the terms of the contract. For example, if the contract said that it was a non-exclusive relationship, but in practice they were required to work 38 hours, it's hard to say that they could ever be free to work for others. Another aspect of that recent case, Thomas and Nas, that I mentioned, the tribunal said that the contractors weren't truly contractors because they had a restraint of trade set out, which was seen to be more of something that would exist in an employment agreement. So the restriction to work within a certain zone after they finish working with your clinic was seen to be part of that control and exclusivity risk that made them more likely to be deemed employees for payroll tax purposes. So for contractor agreements, we always suggest not including a restraint. However, as we often say, it really is up to the individual clinic to decide which risks they're willing to take when preparing the agreement and what they think is most likely to protect their business. Another factor is how the practitioner is paid. Traditionally, it's expected that a contractor will set their own fees and be paid for their results as set out in the contract. Contractors are also responsible for their own tax obligations and do not receive sick leave or any other leave payments. There are many ways in which the payments can be structured that we've seen in our experience. For example, from patients paying the practitioner directly, practice managers paying per hour or day or per patient seen, the rebate less the rental of the consulting rooms, or a rebate less a service fee. Each of these structures represents varying levels of risk. However, a payment that is calculated on time given by the practitioner is more likely than not to be an indicator of an employment arrangement. On the other end of the spectrum, an arrangement in which the full Medicare rebate, if that is how you run your practice, is remitted to the practitioner and the practitioner pays the practice a separate service fee, is more likely to indicate the presence of a contracting arrangement. If you don't use Medicare, it might be an insurance payment from an insurance fund, or it might just be a patient fee and how you split that in terms of a service fee. Now, one of the hallmarks of a contracting relationship is an unrestricted right to delegate. Again, in both the contract and in practice, the true contractor should have this, whereas an employee is engaged personally to do the role. Therefore, they do not have an inherent right to delegate. This is another challenging indicator for practice managers, clinic managers, and owners, and it's not difficult to see why. You invest time in ensuring you engage the right practitioner for your practice, someone with the right experience and skills, and you don't particularly want that person to delegate their role under the contract to one of their employees or a different independent contractor, particularly where you can't determine whether that practitioner possesses the experience or skills that you might expect. Another question to ask is who bears the risk? It is said that risk runs with the control of the contract, meaning when you transfer independence and control to a practitioner, you're also transferring the risk. All self-employed practitioners must hold their own professional indemnity insurance. However, caution should still be exercised. Where a contractor's agreement assigns the risk to the practice for work performed by a contractor, it may indicate an employer-employee relationship. If your contractor is a practitioner, your contract should contain a warranty that the independent practitioner will always hold valid and sufficient professional indemnity insurance. And in fact, in some professions, the practitioner, even if they're an employee, still needs to be holding their own practitioner's insurance. We're almost there with this. I know you might find that hard to believe, but true contractors, another one, always provide their own equipment. In some circumstances, like where that equipment is very expensive or specialized, so an example that comes to mind is in medical practice, ophthalmologists spend a lot of money on getting the right equipment to test people's eyes, and I'm sure optometrists are the same as that. Dentists are the same as well. It might be necessary to share resources in this case so that your contractors can undertake the work that's required. As a general rule, however, it is important that contractors are responsible for providing their own tools, and that would include laptops and other equipment required by them to complete tasks for patients. Something for you to think about is access to your practice management software and where that will fall in relation to employment and contractors, because it's a tool that's required, but it's also something as the employer you want to have control over, so that you've got complete records of who has been seen at your clinic. So none of this is simple. If it was, I would not have been asked to come and present today. But look, let me wrap up the last three on this slide. We have touched on them briefly earlier, but true contractors are not entitled to leave, and they're running their own business and not part of yours. In contrast, an employee will be engaged personally and will be tied up in your practice's business. I cannot stress enough that each factor alone is not determinative. For example, even if you structure the payments correctly, if the practitioner has no control over their work, uses only the facilities of the practice, and is not able to delegate, it will still suggest the presence of an employment relationship. These factors are important to consider when you're assessing those you have already engaged, but also looking at future planning. For example, if you know that you would like to have that control or foster a particular practice culture, it might be time to look at employment relationships because you do have that extra control. Okay, these are items I want you to know about and understand, because alongside the common law, which is case law, which is an interpretation of the existing legislation, regulations, and rulings, the main piece of legislation that relates to whether practitioners will be employees or contractors is the Fair Work Act. It governs Australian workplaces. It's a federal piece of legislation, so every state and territory is required to comply with the Fair Work Act once you're employing people, even if you're employing yourself. It is the foundation for all the standards and regulations for employment. So every employer needs to be familiar with it. However, there are other things that are nestled within this this act, and other obligations that you have to comply with to consider as well. So nestled under the Fair Work Act are the relevant awards. These awards set out the specific minimum wages and working conditions per profession. There's also an award that covers most allied health professionals and also your support staff, which is the the Health Professionals and Support Services Award, which hopefully you already know about or you're going to become well acquainted with in the near future. These awards detail how entitlements, such as how many breaks an employee should be provided with, what overtime hours are, and details about allowances for travel, training, or uniforms exist. Also, as an employer, you need to be familiar with any ATO obligations like income tax and pay-as-you-go withholding tax. This is where practices run into difficulties. This is because the ATO has been given broad powers to audit and recover tax, and they have the authority to make a determination about whether your contractors are in fact employees for tax purposes. Calling someone a contractor means very little to the ATO, because if the ATO views your relationship as your contractor to your practice as an employee relationship, they will very likely enact their powers to recover that tax. The other piece of relevant legislation is included is the Superannuation Guarantee Administration Act 1992. And that governs your practice's obligation to pay superannuation. It's important for you to know that engaging a contractor does not automatically relieve you of the obligation to pay superannuation. Under the Superannuation Guarantee Scheme, if you pay a contractor mainly for their labour, you may be required to pay superannuation. There are also rulings by the state revenue officers and workers' compensation obligations to consider. Sometimes contractor relationships are used by employers to avoid their obligations. If the Fair Work Ombudsman finds that you are intentionally avoiding your obligations by directing employees to undertake work as contractors, you can be fined up to $93,000 per contract. So that's for businesses with fewer than 15 employees. If you're over 15 employees, the amount is $496,500 per employee. So you can see how that would very quickly add up as well. Also on that list there is state revenue office rulings. So that's if you're in a position to be needing to pay payroll tax. It's a different amount in every state and territory, and the state revenue rulings are generally different for every state and territory at the moment as well. So feel free to get in touch to discuss that if you're a larger organisation and you're concerned. But otherwise, for smaller businesses, it's something to be aware of and keep on your radar. The case I mentioned earlier was just one example where a practice unintentionally got it wrong, one of our clients, and faced subsequent hefty bills. It highlights the importance of making sure that you correctly classify practitioners and understand the obligations that then attach, so that you don't accidentally not pay the requisite entitlements, whether that be for payroll tax, superannuation, or other leave entitlements. And another thing to be aware of as a clinic owner is it's something that changes all the time. So we recently had somebody come back to us who had an agreement drafted in the year 2000, so 4 years ago now, and it was out of date. They'd been using that same agreement and not updating it, and they were at risk of a number of things that have changed since that time. So having a regular review of your arrangements on your list to make sure that you're not accidentally becoming obliged to pay these additional entitlements is really important. It's not something that you should set and forget. And one of the ways to keep up to date is really putting regular email reminders from different providers. So, for example, the Fair Work Ombudsman sends regular emails in relation to changes to the law. You Legal, my firm, we do a regular newsletter twice a month to update health practitioners and clinic owners on changes to the law that are relevant for them. Because unfortunately, not knowing or not understanding these obligations won't protect you. You, as the clinic owner or practice manager, need to keep on top of the changes as well as understanding what the law is right now. Because, look, it isn't all doom and gloom. There are steps you can take to minimise risk to your allied health clinic. It is wise to leverage the expertise of someone with significant experience in this space to help you ensure you're acting within the parameters of the law. We suggest engaging a specialist in health law. What we find with our practice is that we have our clients are so grateful that they don't need to educate us on on what's normal within the industry, because we already know it's what we do day in, day out. And feel very blessed and privileged to do that too, because as specialist lawyers for health professionals, we feel like we are helping people who help people, which we are. And it's a real privilege for us to be able to do that. It means that we are part of a ripple effect for good in the country. And it's something that we never take lightly. As specialist lawyers for health professionals, we can help you get the structure of your contracts right, or review what you already have in place. Because we have had a number of people coming to us in the last few months in particular, using contracts that they've been sold by a non-lawyer that are not up to date with the law and provide significant risks for them that they don't even know that they're taking on. So we're very grateful to work in this space, and it's important that you understand after attending this session that the contract alone is not enough. It must be considered alongside the practical aspects of the engagement. So just because the contract says something, it doesn't mean it's going to protect you. Just before we come to the close of this session, I'd like to share an example of a client of ours, another client that approached us recently. They were uncertain of the best method of engaging a psychologist as they were growing, and consequently the appropriate contracts to use. We took the time to understand their objectives and how they envisioned this new psychologist's role within the practice, and the level of control that they wished to maintain over the practice. After a thorough explanation of the different engagement models and some education as part of that as well, we clarified the implications of each option for their practice, because in this particular case, the practitioner had a very strong view about how they wish to be engaged, which I mentioned earlier does happen from time to time. We clarified the implications of each option for their practice, and such as the limits that they might face in fostering a culture, or even in requiring adherence to the practice's policies. For example, if they were to try and exercise such control over a contractor, it could put them at risk of positioning themselves as an employer anyway. However, certain parts of their intended relationship did reflect a contracting relationship. Based on this, we provided a detailed letter of advice which empowered them to make an informed decision. We're now assisting them to draft an employment agreement to align with their chosen approach, and they have worked with the practitioner to get them over the line on that model as well. So there is often a fair bit of internal marketing that a clinic owner needs to do to a new person to make sure that they understand why a particular structure is being suggested, and that that the approach is agreed on by both parties, and the understanding of why that approach has been agreed on as well. Here's my summary of best practices for you to consider as you are moving to engage new team members. Because this case study shows how important it is to think about the distinction before you engage the practitioner. But also, of course, as we have highlighted, the correct classification is an ongoing obligation for the current practitioners working in your practice. We do recommend exercising caution and not making the incorrect assumption that because it says independent contractor on the contract, that it means it's a contracting relationship. The safest way to engage is to engage legal professionals who are experts in the health industry to get the structure of the relationship and contract right in the first place, but also regularly assess the arrangement and review and update the contract if that's required. As I mentioned, an earlier client coming back to us after not having reviewed their agreement for 4 years. A lot of change in the last 4 years because it's a complex and dynamic area of law. Given each and every health practice and relationship is unique, it makes it all the more important not to chase a blanket solution that's going to apply to every situation, because that's really just not possible. So hopefully after attending today's session, you really have more of an understanding of the legal nuances surrounding practitioner and other people engagement with your practice. Engaging professionals, whether it be us as your lawyers or other lawyers, and also talking to your accountant, although understanding that they're not a lawyer, can help mitigate risks in your practice, and overall that can save you significant amounts of money. Seeing a lawyer, I think, in situations like this is another form of insurance really for your practice, because you might pay up front, but you never really know the risks you're avoiding. And in my experience, it's absolutely worth that for this area of law. And also, if you are in partnership with others, having having a shareholders agreement with them is another insurance that hopefully it's a document you put in writing and never have to pull out of the drawer again. But you know, you feel safe in having that in place. So now it's up to you to consider, do I need legal advice and documentation support in relation to engaging people in my clinic? Another area that people are really leaning into in relation to employment is the engagement of virtual assistants, whether overseas or in person. And that's really a whole nother rabbit hole. We do help people with VA agreements, whether they're overseas or in Australia, obviously covering Australian law, all of the issues for health that apply to engaging people internationally, particularly to do with privacy and confidentiality for patients. It's not an area to enter into lightly, even if somebody's told you that it's a quick fix. I guess it's a point to put here at this conclusion point to really be thinking about and getting advice about. It's something that many allied health professionals also talk to their insurer about before they do it, which we would recommend as a first step, probably, if that's something that you are looking at, because you want to make sure that your insurance responds in all instances, not just in some. If you have felt like, which I have in my own business, that you've got this problem that you need to solve, and you need to solve it quickly, to make sure that your patients or clients can be properly served, slowly but surely. Hire slowly, fire quickly, they say. Part of that hire slowly, I suggest, is making sure that you're properly advised from an expert. Now, if you do have any questions or any feedback, I've popped my details on this slide here. I would love to hear from you in any way. Look, I've put my the office phone number, my direct email address. I've put an option for you to book a call with me. I do complimentary 15-minute calls with you, and then my LinkedIn if you'd like to connect and see what sort of value you can get through me posting on LinkedIn, which I do regularly as well. Thank you for listening all the way to the end. I would love to hear from you about what you got out of the session. And also, I do wish you every success in your practice journey, and thank you for what you do in the world as well. All right, look forward to keeping in touch.